Two of the world's most influential privacy laws sit on different continents, built on very different ideas about who controls your data. One treats privacy as a fundamental human right, the other treats it as a consumer protection. Here's how the EU's GDPR and California's CCPA really differ. Start with the mindset behind each law, because it explains almost everything that follows. In the European Union, privacy is treated as a fundamental human right. The General Data Protection Regulation, GDPR, builds on that foundation, and it has been in force since the 25th of May, 2018. Its default assumption is protective. An organization should not process someone's personal data unless it has a clear, lawful reason to do so. California starts from a different place. The California Consumer Privacy Act, CCPA, frames privacy as a consumer protection issue, closer in spirit to the way the United States regulates advertising or product safety. It took effect on the 1st of January, 2020, and it was strengthened by the California Privacy Rights Act, the CPRA, effective the 1st of January, 2023, with enforcement from the 1st of July that year. The CPRA also created a dedicated regulator, the California Privacy Protection Agency. So one system says protect the person by default, and the other says empower the consumer to push back. Keep that contrast in mind, because it shapes every difference we cover. Now consider reach, because the two laws are not aimed at the same organizations. GDPR is deliberately broad. It applies to any organization, of any size, that processes the personal data of people in the EU. A multinational bank and a two-person startup are both in scope if they handle that data. There is no revenue threshold to cross and no minimum number of customers. If an organization holds the data, the rules apply. CCPA is narrower and more selective. It applies only to for-profit businesses that do business in California and meet at least one of three thresholds. The first is having more than $25 million in annual gross revenue. The second is buying, selling, or sharing the personal information of 100,000 or more California consumers or households. The third is deriving 50% or more of annual revenue from selling or sharing personal information. Miss all three, and CCPA generally doesn't apply to that business at all. So the practical test is completely different. Under GDPR, the question is simply whether an organization touches the data of people in the EU. Under CCPA, the question is whether a business is large enough, doing business in California, and crossing one of those three lines. If you remember only one difference, make it this one. GDPR runs on an opt-in model. Before an organization processes personal data, it needs a lawful basis, and there are 6 of them, ranging from the individual's consent to a contract, a legal obligation, or a legitimate interest that is carefully balanced against the person's rights. No lawful basis, no processing. Consent, where it is used, has to be freely given, specific, and unambiguous. CCPA runs on the opposite model, opt-out. A business is generally allowed to collect and process personal information, and the consumer's power is the right to step in and say stop. In practice that means the familiar do not sell or share my personal information link, which lets a Californian opt out of having their data sold or shared. The burden simply sits in a different place. Under GDPR, the organization must justify the processing before it begins. Under CCPA, processing is presumed acceptable until the consumer objects. Same goal, giving people a say over their data, but the default setting is flipped, and that single design choice ripples through consent banners, privacy notices, and compliance workflows on both sides of the Atlantic. Both laws hand individuals a real toolkit, but GDPR's is the broader of the two. Under CCPA, as strengthened by the CPRA, California residents get the right to know or access the information a business holds, the right to delete it, the right to correct it, the right to opt out of the sale or sharing of personal information, the right to limit how sensitive personal information is used, and the right to non-discrimination for exercising any of these rights. Meaning a business cannot simply penalize someone for opting out. GDPR covers that ground and goes further. It grants access, rectification, and erasure, often called the right to be forgotten, plus the right to restrict processing, the right to data portability, and the right to object. It also sets specific rules around automated decision-making and profiling. And GDPR can require an organization to appoint a data protection officer, a formal role that CCPA does not mandate. There is even a difference in language. GDPR protects personal data, while CCPA protects personal information, and California's definition notably reaches household-level data, not just individuals. Different vocabulary, overlapping rights, but a wider net on the European side. Enforcement is where the difference in philosophy turns into a difference in numbers. Under GDPR, the most serious violations can draw fines of up to 20 million euros, or 4% of a company's global annual turnover, whichever figure is higher. For a large multinational, that percentage can dwarf the fixed cap, because it is calculated on worldwide revenue, not just European sales. Enforcement is handled by data protection authorities in each member state, coordinating across the EU. California takes a more measured, per-violation approach. Administrative penalties run up to $2,500 for each violation, and up to $7,500 for each intentional violation, or violations involving minors. Those are enforced by the California Privacy Protection Agency and the State Attorney General. CCPA also includes a limited private right of action, which lets consumers sue directly in certain data breach situations, something GDPR largely channels through regulators instead. So GDPR leans on large, turnover-based fines, while CCPA stacks smaller, countable penalties and adds a narrow path for individuals to bring their own claims. Here is the trend worth watching. For years, California stood almost alone inside the United States. That is no longer true. A growing list of states, Virginia, Colorado, Connecticut, and Utah among them, have passed their own consumer privacy laws, each with its own definitions, thresholds, and rights. For organizations operating nationally, the result is a patchwork. A single business may find itself navigating several overlapping state regimes at once, rather than one federal standard. What is interesting is the direction of travel. Many of these newer state laws borrow concepts that feel distinctly European: clearer duties for the businesses that decide how data is used, stronger protections around sensitive information, and more explicit consumer controls. Piece by piece, U.S. practice is drifting closer to GDPR-style expectations, even without a single national law to mandate it. For teams trying to stay compliant, that convergence is arguably good news. Building toward the stricter, GDPR-shaped standard increasingly covers much of what the newer U.S. laws ask for as well. The two philosophies we started with are still distinct, but the distance between them is quietly narrowing. If breaking down the rules behind the headlines is useful to you, subscribe to Compliance Decoded. It is where we translate dense regulation into plain English, one topic at a time. And we would genuinely like to hear from you. Which privacy framework does your team wrestle with most? GDPR, CCPA, or one of the newer state laws? Drop it in the comments, and tell us which regulation you would like decoded next. Educational overview only, not legal or compliance advice. Consult a qualified professional for your situation.